Hearing 15D, Day 1 with an opening karakia. Whakataka te hau ki te uru, whakataka te hau ki te taonga. Kia mā kinakina ki uta, kia mā tarata ki tai. Kia hi aki ana te atakura, hi tio, hi puka, hi haupu, ti hei, mauri uta. Thank you.
Now my hane mai ki tēnei hui, ko Robert Scott Pekaringo. Good morning everyone and welcome to hearing 15D, which concerns requests for urban zones within land within the Kerikeri-Waipapa Spatial Plan area. My name is Robert Scott, I'm the chairperson for these hearings. With me from my right to left is Councillor Felicity Foy, Commissioner Peter Kensington, and Commissioner Alan Watson. I just wish to add for the record that if Councillor Foy were not returned to council following the local body elections, she will remain on this panel as an independent hearing commissioner, both having received certification under the Making Good Decisions program. In the meantime, we wish her well for the upcoming election and please get out and vote. I should also note that Councillor Foy has decided to stand down from hearing the Kiwi Fresh Orange or KFO submissions on the basis that she voted on the Kerikeri-Waipapa Spatial Plan and the addition of KFO as option F to the Spatial Plan. I note that her decision also resolves a scheduling conflict with her, and she can now attend an extraordinary council meeting tomorrow that considers, amongst other things, development contributions. So this is a hearing under Act 1991 to consider submissions and further submissions on the proposed Far North District Plan relating to this topic. We've been appointed by the Far North District Council as independent hearing commissioners to hear these submissions and make recommendations to the council on any changes to the district plan as notified. We're not intending to issue interim recommendations at this stage, and we will be hearing all the submissions before issuing a complete set of recommendation reports. That said, we intend to hold interim deliberations at the conclusion of each hearing topic. In the interests of natural justice and efficiency, until our final recommendation reports are released in late March next year, any deliberations will remain confidential. The exception to this will be where the panel agrees to release interim guidance. Very quickly, my background is in planning, and I've been a planner since 1992 and an independent hearing commissioner since 2014. I'll just get the others to just quickly introduce themselves for the record.
Kia ora, I'm an elected councillor, but I'm also a full member of the New Zealand Planning Institute and qualified planner, and I'm also a farmer and a businesswoman, and I'm 2 kids.
Kia ora tātou. I'm a landscape architect and planner, and I work for myself based at Moorwana Beach in Edmund.
I'm a planner, Alan Watson. I'm a planner and I do commission work around the country and been around the coast for a few years.
Okay, so today I think we're focusing on the council's summary of this topic, and I think we have till about 3 o'clock today for that to happen.
That's correct, Mr. Chair. Mr. Tim Fisher will be leading out today for us.
Okay, so we're going to have some legal submissions as well from Mr. Fisher. Okay, well, before we hand it over to you, we'll just go through the housekeeping matters, which I'll get Alicia Kate to go through.
Sure. So if you haven't found the bathrooms already, they're out the back double doors and turn right and down to the left. In the event of a fire, we have 2 exits to choose from, and then assembly is on the back lawn, kind of through the car park. If everyone can just make sure they've got their phones on silent and laptops on mute. We are recording today's session and it will go online at the end of the day. The microphone is here, and so if everyone can just kind of, their voices loud enough. And so the morning session, as Robert said, is running until 3 o'clock, and we will have a morning tea and a lunch break as we see fit in that. So whether that's Tim or Robert that kind of directs that, we can go with the flow. Yeah, that's us.
Great. So we received on Saturday some evidence summaries from all of the council officers. We'd like to, we've very quickly read them. We're quite happy to have each officer read that summary to us. I think that would be quite helpful. There's a lot of information that we've read in quite a short space of time, so I think we'll be assisted if they were to be read out, and feel free to embellish anywhere that you feel you need to. So on that note, I'll hand it over to you, Mr. Fisher.
Kia ora koutou katoa. Good morning to the panel, council officers and submitters, members of the community that are here. I have prepared some legal submissions which have been uploaded to the council website, and I assume everyone has access to those.
They have been sent. I do have printed copies as well. Do you guys want a copy? Yeah. Anyone else want to do it? Yeah. I've only got one more. That's good.
I think we all have a copy, Mr. Fisher. Thank you.
Thank you. I will note at the outset we've got until 3 o'clock to get through this, but there is quite a lot to get through, so we are going to have to try and keep things moving. There are parts of these I'll try to move a little bit quicker, so we don't cut the witnesses short, because I think 3 o'clock will come up there, I suspect.
Yes, and of course we'd like to ask a number of questions as we go, so we can be guided by you as to when you think questions should be asked, or perhaps after each presentation.
Yes, I think so. I think saving them till the end of the case will probably not be feasible, because there's so much, people will forget the questions and we might run out of time. So I think for the witnesses, perhaps at the end of each of their overview summaries, would be a good time. For my part, I'm happy to take questions as I go. If they pop up while I'm going through it, I'm happy to answer any questions as we go, or saving them to the end, I'm fine. Either way. So starting at the introduction at paragraph 1.1 of the submissions, this hearing relates to requests for the urban rezoning of land at Kerikeri-Waipapa under the proposed district plan of the Far North District Council. The Section 42A report has been prepared in part by Ms. Trinder and in part by Mr. Wyeth. Ms. Trinder addressed all rezoning requests except a request by Kiwi Fresh Orange Company Limited, KFO as we will call it, seeking rezoning of approximately 197 hectares of land between Kerikeri and Waipapa from rural production zone as notified to urban zoning, a mix of general residential, mixed use, natural open space. This submission is addressed by Mr. Wyeth. Collectively, the rezoning requests raise very important issues about the future urban form of Kerikeri and Waipapa, the impacts of urban development, the quality of urban environments, and the outcomes that will be enabled, and the efficient planning, funding, and delivery of infrastructure. These issues have been recently considered by the Council in preparing and adopting Te Patu Kerikeri-Waipapa Spatial Plan, which I'll just call the Spatial Plan going forward. The need for a district plan which enables greater development capacity than the notified version of the PDP is acknowledged in the Section 42A report. However, a key matter for the hearings panel to consider is where and how that additional development capacity should be provided. Integration between land use planning and infrastructure planning and funding is a central consideration. The planning merits of the respective rezoning requests are addressed in the Section 42A report and are not repeated here. And I'll add to that, it's not my role or intention to tell the panel how to exercise their planning judgment. What I'm doing in these submissions is addressing the legal issues that have arisen. As far as the planning merits and so on go, you have independent professional recommendations from Mr. Wyeth and Ms. Trinder, and that's what we go on, rather than being a legal question as such. These submissions have been prepared without seeing the legal submissions on behalf of the submitters, although I have had a brief reading of the KFO submissions which came in over the weekend. It is therefore anticipated that some issues raised in those submissions may need to be addressed in reply. So that's the introduction, and over the page at section 2, I've got an outline of the submissions. I won't read through this, perhaps I'll take this as read because we're going to get to them each one in due course anyway. Down at 3.1, Section 42A report summarises and evaluates submissions on the notified PDP and makes recommendations as to whether there should be any amendments in response to those submissions. We've covered 3.2, the Section 42A authors, and then 3.3 are the list of witnesses in support of the Section 42A report. And we're going to call the witnesses generally in this order, in the order listed. I will note that Mr. McDonald's not available, unfortunately. We can take questions back to him, and if there's a need to call him later in the hearing, we could potentially arrange that as well. All the witnesses are here in person, except the final two, the ecologist, Ms. Andrews, and the soils rural productivity expert, Dr. Hill. They'll be appearing remotely. The Section 42A authors have also relied on other experts, which are referred to in the Section 42A report. The hearings panel will first hear an overview from Ms. Trinder. She has some slides to present you in the usual way, and that'll be followed by Mr. Wyeth, who also has a slide set for you. At paragraph 3.5, as noted above, the need for a district plan which enables greater development capacity than a notified version of the PDP is acknowledged in the Section 42A report. However, the difference between the Section 42A authors and some submitters relates to where and how the additional development capacity should be provided in the context of Kerikeri-Waipapa. Ms. Trinder recommends a package of changes which she describes as the PDPR. The PDPR includes the following: medium density residential zone over parts of the existing general residential zone land, town centre zone over parts of the existing mixed use zone land, upzoning of 23 Aranga Road from rural residential to general residential zone, rezoning 7.7 hectares of land at 126 Kerikeri Road, and associated land holdings from general residential to mixed use zone, and introduction of a minor residential unit as a permitted activity, and minor provision changes recommended through hearing 14. And that's just a very brief overview. Ms. Trinder will be able to explain that to you in a bit more detail when she appears. This is primarily a package that provides for greater intensification through application of the medium density residential zone and the town centre zone with associated policy and rural frameworks. Mr. Wyeth considers this as the most appropriate way of providing sufficient development capacity for Kerikeri-Waipapa. He recommends that the KFO proposal be rejected for a number of reasons, which are set out in part in his part of the Section 42A report. At Section 4, I set out the statutory framework, and this is probably more in the category of belts and braces. I don't think I'll read through the whole thing. I'm sure the panel is familiar with the statutory considerations.
Is there any particular part of that? Is it that they particularly want us to focus on that relates to these matters, or is it the general matters that we've been considering throughout the hearing?
I think where there are particular matters to have attention, give attention to, they've got their own heading later on. So I think we can probably take this as read if the panel's comfortable with that. I will note in paragraph 4.2, minute 14 of the hearings panel sets out general criteria for evaluating rezoning submissions. These criteria provide a convenient way of framing the statutory considerations in the context of rezoning requests and have been followed by the Section 42A authors. So that is more the format of the 42A reports is to follow the minute 14 criteria, which embody these statutory considerations in a more targeted and tailored way in the context of rezoning requests. At 4.1, I set out the requirement to give effect to. This is well-established case law, King Salmon. It's been around for a long time now. We've all heard it before, of course, so I'll take that as well. And then we've got the meanings of particular words, mandatory and directive language from paragraph 4.8. And these words mainly come up in the context of a national policy statement on highly productive land. So we've got meaning of the avoid. At 4.10, avoid means avoid, you can't override it with part 2, etc. We're all familiar with that. Meaning of protect, again, another mandatory and directive word, and meaning of inappropriate, depends on the context that it's being protected. So hopefully we can save a bit of time by taking that all as read. If there are any questions that come up later, I'm happy to answer them on those. But as I say, we've mainly followed minute 14 criteria in terms of the statutory considerations.
I'm just wondering, I mean, you refer to that sort of quite directive language, and in the context of NPSUD, where council's accepted that it is a Tier 3 local authority and it isn't mandated to do anything other than remove car parking, how does that directive language relate to a Tier 3 local authority that isn't required to do most of the things, encouraged but not required to? Is there sort of like a resolution of those two, directive versus voluntary?
The objectives and the policies of the NPSUD still apply. So each one needs to be looked at in its own terms and interpreted and applied. And the language for some parts of it of the NPSUD are mandatory and directive, like the requirement to have sufficient development capacity as a mandatory and directive requirement. There's no discretion built into that. You have to provide sufficient development capacity. So that's one example which does apply. You have to have well-functioning environments and so on. So there are aspects of the NPSUD which will apply and apply, but the wording needs to be looked at very carefully in each case. That's the key point. Each provision.
Okay, thanks.
At paragraph 5.1, a list of relevant file order documents, most relevant. National Policy Statement for Urban Development, as we've just touched on. National Policy Statement for Highly Productive Land. National Policy Statement for Indigenous Biodiversity. National Policy Statement for Freshwater Management. National Planning Standards, and the Northland Regional Policy Statement. Those are the key ones. Paragraph 5.2, as noted above, each of these documents must be given effect to, which requires a careful analysis of each of the relevant provisions and reconciliation between them to determine what is required to give effect to them. And that's exactly what we're discussing. This exercise is undertaken in the Section 42A report by Ms. Trinder and Mr. Wyatt, and is not repeated here. At a broad level, the relevant high order documents include both protective and enabling themes. For example, matters requiring protection relate to highly productive land, wetland extent and values, and natural hazard risk. The enabling theme is reflected in provisions such as those providing for urban growth and ensuring sufficient development capacity. In Garden Trust v Auckland Council, the Environment Court noted the potential for conflict between the NPSUD and the NPSHPL. It noted that in the first instance, decision makers should seek to find a way in which both policy statements can be met with a decision required where they are incompatible. In the present circumstances, I'm not aware of any obvious conflicts which cannot be reconciled by interpreting documents. So again, in every case, it's a matter of going to those documents and looking at the wording. If there's any apparent conflict, you look at closely look at the wording and look to resolve it between the documents. What's put in a more directed way and what builds in latitude and discretion, etc. Go through that type of exercise if any of these things arise. At section 6, I address potential changes to national directions. The government is proposing 4 new pieces of national direction and amendments to 12 others. Reforms have been grouped into 4 packages: infrastructure and development, primary sector, freshwater, and going for housing growth. Consultation on the first 3 packages closed on 27 July 2025, and under the new streamlined process, the amendments are expected to be in effect by the end of 2025, although it has been a while since we had an update on that. Watch this space, I think. But paragraph 6.3, the freshwater package includes replacement of the EPS-FM objective and changes to the EPS-FM and the NES-F in relation to wetland management, especially the treatment of artificial wetlands provision for farming activities and wetland construction. The going for housing growth package is being progressed separately. The discussion document was released on 18 June and consultation closed on 17 August 2025. The proposal in the discussion document would change the approach to the EPS-UD, but it's not yet clear exactly how. This will be determined as part of developing the new resource management system, formed by feedback on the discussion document. The proposed changes are therefore not relevant to this PVP process.
I have a question about the timing. Under 6.4.
Yeah.
And under 6.2, it notes that central government are to have, well, they're saying that the new streamlined process allows for that to be in effect by the end of 2025. Our district plan won't have the decisions written into council until 2026.
Yeah.
Is there any direction from central government how that works for the council like us through this process?
Yeah, I do get to that in the next few paragraphs, and I think the short answer is that we don't yet know exactly what the transitional provisions are, and it may be something that the panel needs to come back to a bit later on in the process. But I will talk to that a bit more through the next couple of paragraphs. The most relevant changes are those relating to the EPS HPL. It came into effect 17 October 2022 to protect highly productive land for use in land-based primary production. There appears to be no dispute that the KFO site includes 163.1 hectares of highly productive land in accordance with the transitional definition under clause 3.5 subclause 7 of the EPS HPL. And I've just footnoted there some fairly well-known case law at this point about how you determine that using the NZLRI maps, which were in place at commencement of the regional policy statement. The current transitional definition applies to land that is classed as LUC 1, 2 and 3. However, the government's discussion document proposes to remove LUC 3 land from the definition of highly productive land and consequently the NPS HPL restrictions with immediate effect. The government intends that the amendments to the NPS HPL will be drafted after the consultation phase, so that it hasn't been done yet. But we do need to consider perhaps a legal issue of what is the relevance of that consultation document, which is what I get to in 6.7. There is nothing in the RMA that directs decision makers to consider discussion documents. In Main Power New Zealand, the Environment Courts considered draft national policy statements for context, but did not place any weight on them as they were subject to change. This approach is equally applicable to discussion documents. in short, we've got uncertainty about what's going to eventuate from this government process. Paragraph 6.8, I'm getting here to Commissioner Foy's question earlier. If amendments to the national directions come into force before the hearings panel makes its recommendations, the effect of those amendments must be considered by the hearings panel. This is required by Article 55 of the RMA, which provides that local authorities must, using the Schedule 1 process, make amendments to a proposed plan that are required to give effect to any relevant provision in the National Policy Statement as soon as practical, or as and when directed by the National Policy Statement. At 6.9, the current NPS HPL must be given effect to unless and until any amendments come into force. Because the final form of any amendments to national directives is not yet known, it is unclear what the transitional arrangements will be, and it is premature to comment on how potential amendments to NPS HPL would affect the PDP decision-making process. If the NPS HPL is amended prior to the hearings panel's recommendations, the hearings panel may consider seeking submissions from the parties. So until we know the detail, it's too early to say how it's going to affect this process.
Well, it sets up an interesting, I mean, we're under quite a tight time frame to do our recommendation. It's the council to consider and release a decision. Yeah, it might be that your recommendation is to potentially extend that period in order to allow submissions on that and possibly other matters.
Well, I think there's a lot of moving parts here, and it's hard to.
If we would need, if in the interest of natural justice and giving effect to those national instruments is important, but we're hitting a hard deadline to release decision. Who decides whether that gets moved? Is it the Minister for the Environment?
The deadline for completion of the plan?
Yeah.
Yes.
Well, can it be extended?
Yes, it is the Minister. It is the Minister
Yeah.
that will extend that. But ultimately, I think in the first instance, it's the panel that's going to have to look at all the circumstances and around the timeframes we've got, the constraints, and decide on a process that is fair and appropriate in accordance with Section 39 of the RMA.
Yes.
Weighing everything up, timeframes, outcomes, fairness, all of that, and come to a procedural position on how these proceedings are going to continue or not.
And there may be several national instruments by the time decisions are scheduled to be released. And something might happen between us completing recommendation reports and council considering those reports.
Yeah.
We need to sort of consider all of those sorts of potential outcomes, shouldn't we?
Yeah. I think having the amended documents in front of you would potentially make that task a bit easier in terms of how entering into a further submission type process and potentially delaying things, how it would impact the PDP process. Yes. It is something ultimately for you to decide.
Yes, thank you. Thanks. Something like a bit of uncertainty.
Yeah. We're unfortunately used to it in this space, especially in the last few years. At Section 7, I've got a section on the pausing of significant natural areas under the National Policy Statement for Indigenous Biodiversity. And I have addressed you on this some time ago when the changes were still a bill. They're now in Act, so this is effectively a bit of an updated section. At 7.1, the PDP process was mid-flight when the NPS IV came into force. Because the PDP was notified prior to this, it did not fully give effect to the NPS IV, including the provisions relating to identification of new significant natural areas. The Amendment Act subsequently came into force. It was passed to implement the government's announcement that requirements for identification of new SNAs will be suspended for a period of 3 years. The Amendment Act inserted a new Section 78 into the RMA to disapply NPS IV requirements for the identification of SNAs and district plans and to disapply the clause 4.1 requirement to give effect to SNA provisions as soon as reasonably practicable. These provisions are proposed to be disapplied for a 3-year period ending on October 2027. At paragraph 7.4, I set out the mechanics of the changes. Perhaps I'll take that as read.
We've wrestled with this one way back in period number 4.
Right.
I think things have changed since then. I mean, it's good to have it on record.
Yeah. Well, I think perhaps since that hearing, what's happened is we've moved from a bill to an amendment act. So it's been through the parliamentary process, but there weren't really substantive changes from the bill. So you should be reasonably familiar with it. So I think we can, on that basis, we can take 7.4 as read. It might be worth reading out 7.5, which is the implications of these changes, which may take things a little further. The proposed changes do not remove the Council's obligations to give effect to the NSIB provisions which are related to identification of SNAs, to maintain Indigenous biodiversity under Section 31 of the RMA, to recognise and provide for protection of areas of significant Indigenous vegetation and significant habitats of Indigenous fauna as a matter of national importance, to have particular regard to the intrinsic values of ecosystems under Section 7D, and to give effect to the RTS. Paragraph 6.4, I know what we've already been over, which we've gone, is that we've gone from a bill to an act. So I won't read that out. At 7.7, the RMA requirements described above remain relevant to consideration of the KFO proposal. There continues to be strong recognition of Indigenous biodiversity under the RMA, despite the pause on mapping of SNAs. The ecology effects of the KFO proposal are addressed in the evidence of Ms Andrews and in Mr Wyatt's Section 42A report. Moving to the next topic, Section 8. The NPSUD is a national policy statement which provides direction to decision makers under the RMA in relation to development capacity for both housing and business. It's directive. So it's directive and prescribes a range of relatively complex planning, monitoring and decision obligations. I think we have touched on these NPSUD matters and also the point that the council is a Tier 3 local authority. So perhaps we can take those as read and go down to that's paragraph 8.9.
Yeah, maybe we just touch on paragraph 8.8. It was something I referred to last hearing. Maybe.
Yeah.
I think you should probably.
Okay.
Could you address that one?
Because the council is a Tier 3 local authority, a number of NPSUD provisions do not strictly apply. However, clause 1.5 provides for implementation by Tier 3 local authorities as follows. Tier 3 local authorities are strongly encouraged to do things that Tier 1 or Tier 2 local authorities are obliged to do under parts 2 and 3 of the NPS, adopting whatever modifications to the national policy statement are necessary and helpful to enable them to do so. As a Tier 3 local authority, the council is not required to prepare an HBA under the NPS. However, it elected to commission an HBA from Market Economics Consulting in July last year, as encouraged by clause 1.5 of the NPSUD. So the council has acknowledged that encouragement in the NPSUD and implemented it. The HBA followed the general structure of the NPSUD, but the approach has been tailored to suit the Far North District. And Mr McElrath can address you further on that. The HBA assessed development capacity under the notified PDP by estimating current and future demand capacity for residential and business activities and evaluating the overall sufficiency in the short, medium and long term. HBA concluded that under the notified PDP, there is sufficient business land, assuming a portion of growth will occur through redevelopment of existing sites and more intensive use of land resources. The HBA shows sufficient plan-enabled capacity at both the district-wide and Kerikeri-Waipapa level for both housing and business land. However, due to feasibility constraints and assumed uptake rates, the HBA predicted capacity deficits for detached dwellings in both Kerikeri-Waipapa and the wider district. The NPS therefore requires the council to change the notified PDP to provide sufficient housing development capacity as soon as practical, including through the submissions process. The PDPR was devised and modelled to demonstrate sufficient development capacity in combination with the spatial plan as set out in the Section 42 evaluation and the evidence of Mr. McGrath and Mr. Lindenberg. The requirements for sufficient development capacity are set out in clause 3.2 of the NPSUD. Mr. Lindenberg steps through that provision and his evidence is not repeated here. However, it is worth noting that the first requirement for sufficient development capacity is that it be plan enabled in the short term, medium term and long term. Under implementation clause 3.11c, if the council is not required to have a future development strategy, as is the case for a Tier 3 authority, any other relevant plan or strategy may be relied on. The spatial plan may therefore be relied upon by the council for long-term plan-enabled development capacity. The NPSUD does not require 30 years of development capacity to be included in the PDP.
Can I just ask a question about that? So previously you said a Tier 3 local authority isn't required to do an HBA.
Yes,
yeah, correct. But they are required to meet or to provide capacity in the short, medium and long term.
Yes.
I'm just wondering how, if the local authority chooses not to do an HBA, how on earth would they do that? How do they achieve that?
I think the point is that the requirement for sufficient development capacity is applicable. It's in the policies and it's applicable. But what the NPSUD does is it gives more flexibility or latitude in terms of a methodology for determining capacity. So it's less prescriptive. But the approach of the council is that, well, we've got a prescription in the NPSUD already, which is understood and helpful, and it's largely been the approach that the council's taken, but it's not strictly required. So it's a useful model to approach on. But we do have more flexibility being the Tier 3 authority.
So they're under the same obligation to provide for capacity.
Yes.
But with a Tier 3 local authority, the NPSUD isn't that worried about how you get there.
It's less prescriptive.
I know that sounds a little bit flippant, but
less prescriptive and more flexible about how you get there for a Tier 3. They're not held to quite the standard and rigour that Tier 1 and Tier 2 authorities are.
But notwithstanding that, the NPSUD would encourage a Tier 3 local authority to adopt, under clause 1.5, would encourage them to do an HBA?
Correct.
Yeah.
Correct. And the council is very much taking that on board and largely adopted a similar approach.
Okay, thanks.
Yeah, I have a question
That's a really important point, I think.
Yeah.
Northland has 3 councils. Whangarei is a Tier 2 council. We are a Tier 3 council. Kaipara is no tier. We now have a CCO for our 3 waters. In terms of forward planning, with 3 waters determining if people can connect or not, and the work program determined by the 3 councils when we signed the contract. In terms of the direction, and you state here, any other relevant plan or strategy. So my question is, in the context of that agreement councils have signed up to, and that 3 waters controls growth, how does that interrelate with the NPSUD and how we forward plan when the new CCO will control three waters and what community, not councils as individuals.
Yeah, I interpret that as being any other relevant plan or strategy that's in the nature of a future development strategy. Yeah, I guess it's probably not going to be an issue for this hearing because by the time the new entity comes up with a plan or strategy, I suspect that this process will be largely.
We've already signed a contract for the program of works for the next 10 years.
A contract for the program of works. Yeah, I don't, to me that doesn't, yeah, maybe there's something we can come back to, but the question is whether that's in the nature of a future development strategy, which is what this clause is targeted at. But perhaps we can come back to that.
Thank you.
Thanks, Mr. Fisher.
Paragraph 8.15. While the NPSUD includes strong requirements for councils to provide sufficient development capacity to meet expected demand for housing, it leaves decision makers with scope to determine the most appropriate location for additional development capacity. As noted above, the location and manner in which additional development capacity is provided must be appropriate in terms of the wider NPSUD. For example, it should achieve well-functioning urban environments and enable heights and density of urban form commensurate with public transport accessibility and locational demand. Therefore, does not follow the shortage of development capacity in the notified PDP that the KFO zone must be accepted. The PDPR provides a reasonably practical option, which Mr. Lindenberg and the Section 42A authors consider will give effect to the NPSUD. The inability to demonstrate infrastructure readiness in terms of clause 3.4 of the NPSUD also means that rezoning the KFO land would not fully satisfy the requirements of the NPSUD for sufficient development capacity. The most appropriate location for additional housing development capacity needs to be assessed in regard to all the usual statutory considerations. This would include the broader provisions of the NPSUD, including those which seek well-functioning urban environments, other relevant national policy statements, and the RPS. Is the panel happy with the time that we're taking here? Do you want me to speed it up, or how you?
I'm quite happy with the pace, I think. As long as you don't think we're slowing you down too much.
No, I'm just conscious of what we've got to go, but if the panel's content with this pace, I'll carry on. I will look for opportunities to.
Yeah, we'll have to guide you there.
Yeah. Just let me know if we can shortcut anything, because I don't want to run out of time at the back end of the day.
Yes.
In paragraph section 9, we've got the NPS and the availability of exceptions, and this is in 9.1 I set out policy 5 in NPS HPL, and this is an example of a mandatory and directive provision. Urban rezoning of highly productive land is avoided except as provided in the NPS, so it's a directive provision with a set of exceptions which are set out in paragraph 9.2. The urban zoning must be required to provide sufficient development capacity to meet expected demand. There must be no other reasonably practical and feasible options for providing the development capacity, and the social, economic, cultural, economic benefits of rezoning outweigh the environmental, social, cultural and economic costs associated with the loss of highly productive land for land-based primary production. So clause 3.6 is the only pathway for the rezoning of the KFO land. The provisions are mandatory and directive, meaning they must be applied strictly, and the council may only allow rezoning of highly productive land if each of the requirements in A through C above are met. The conjunctive nature of the sub-clauses was highlighted in Drennan and Selwyn District Council, which applied to in relation to an equivalent clause which applied to Tier 1 territorial authorities. I've just got a quote there, which I'll perhaps give the panel a few seconds to read rather than reading it out.
Yes, so they're all conjunctive. You have to meet all of that.
Exactly. As was the case in Drennan, Mr. Wyeth also considers that the KFA proposal fails at the first hurdle because the rezoning is not required to provide sufficient development capacity to meet expected demand for housing or business land in the district. At section 10.
Sorry, just pause because this thing's been playing on my mind for a wee while. A Tier 3 local authority is given the licence to determine how they're going to go about the methodology of determining its development capacity. Who decides whether that's the right method?
Yeah, I mean, it's going to be.
I might say us.
Yeah. It might not be the answer you hope for, but that is the.
It potentially sets up quite an element of subjectivity. Some subjectivity to say, well, this is the right method because of these circumstances and these things. And obviously, the spatial plan has attempted to do that. Is that really where it sits? That we need to acknowledge that how we arrive at what is sufficient development capacity is a relatively more subjective than tiers 1 and 2. Would that be a fair summary of the situation?
Yeah,
I've been wrestling with this for a little bit.
That's right. It's your task to come up with a recommendation that gives effect to the NPSUD, and within that NPSUD, there's a latitude or about what and how you determine if sufficient development capacity is provided. So it sits with you. Hopefully you can take comfort from the council's approach, Mr. McElraith's approach, I should say, which is to largely follow the methodology that would apply for Tier 1 and Tier 2 authorities. So he's not proposing a radical departure from that. So hopefully you can take some comfort from that. And it is an approach which Mr. McElraith and marketing economics have applied in many other places across the country for Tier 1 and Tier 2 authorities. So hopefully that can give you some comfort.
Yeah, and obviously we're going to be presenting, we have been presenting with an alternative methodology. But the NPSUD is deliberately flexible in terms of which one we would prefer.
Yes,
evidence-based.
That's right. You're going to have a bit of competing evidence here that you're going to weigh up and analyse and decide effectively what you prefer and what is appropriate in the overall circumstances.
Okay. No, thank you. That's really helpful.
At section 10, this is probably quite an important issue. A very topical one and a recent one, which is the relevance and weighting of the spatial plan. So I'll go through this, and there are some cases here which hopefully assist with things. The PDP was notified on the 27th of July 2022. The Council progressed the spatial plan in parallel with the PDP process using the special consultative procedure under the Local Government Act 2002. The purpose, background and development of the spatial plan is explained in the evidence of Mr. Rubin. In this first section, I set out the legal relevance of the spatial plan. As noted above, section 74 of the RMA sets out certain matters that territorial authorities must have regard to when preparing a district plan, including management plans or strategies prepared under other acts. And that's section 74, subsection 2B1. These management plans and strategies prepared under other acts include the spatial plan prepared under the Local Government Act 2002. And I've just put an environmental case there where a similar approach was taken in relation to a structure plan under the Local Government Act. So they are analogous and very similar in their purpose and content. Paragraph 10.4, have regard to means to give genuine attention and thought to the matter. That's what the case law says. This requirement to have regard to the spatial plan must be considered in the context of other relevant statutory considerations summarised above and reflected in minute 14 of the panel. So the short point is that the spatial plan is relevant to your decision and you have regard to it. In the next section is about the weight. The weight to be given to the spatial plan is a matter for the hearings panel. The Environment Court has issued a number of decisions that consider the nature and extent of the consultation process when determining the relevance of and weight to be given to non-RMA documents. In Johns Road Horticulture, the Environment Court placed very little weight on a non-RMA document, but that was where there was uncertainty about how rigorous and careful the consultation was, and there was no submission and hearing process. So we are distinguishing that. In Longview Estuary Estate, the Environment Court agreed a structure plan should be given weight because it represented commitments made between the council and the community and reflected significant consultation and investment by the council in terms of spatial planning. However, the court concluded to the somewhat limited extent that we place weight on the structure plan, the thrust of it should be interpreted in light of the theme of urban consolidation and statutory instruments already discussed. So we've got a progression here in terms of the consultation. Now, in paragraph 10.9, I've got a fairly long quote. I won't read 70 and 71 because that's what the very respective arguing and it's there for context. But in 72, we find that the structure plan is a document which had the benefit of comprehensive public consultation and community engagement. It is also informed by numerous technical reports. It provides a strategic vision to guide future development at Warkworth. It is a document that is relevant to our determination of appeal. So we're progressing towards the more intensive type consultation process.
On my side, I was council's witness for that one.
Oh, right.
The other panel members.
Okay, so you're very familiar with it, but that's going to be right. Okay. And now in 10.10, in Mapara Valley Preservation Society, an Environment Court decision on a resource consent appeal. So it's come up in a slightly different context, but it is still relevant and helpful. The court considered the weighting that should be given to variations in the proposed Taupo district plan that were introduced to implement a strategic document under the LGA02 called Taupo District 2050. The court held, and I've highlighted the key part there, the final sentence, the TD 2050 was publicly notified for consultation in conjunction with the 2006-16 long-term council community plan using the special consultative procedures under the LGA02. We thus should be given substantial respect and weight. Just to wrap that all together in paragraph 10.11, in the cases available, the court was most explicit in relation to the non-RMA document which followed the special consultative procedure and was informed by technical reports, i.e. it warranted substantial respect and weight when given to the implementing variations. Process which was informed by technical reports and involved comprehensive consultation and community engagement in accordance with section 82 of the LGA, but did not follow the special consultative procedure, was confirmed as relevant. There was no specific comment on weight. Whereas it was uncertain how rigorous and careful the consultation was, and there was no submission and hearing process, a non-RMA document was given very little weight. At 10.12, the spatial plan process is at the upper end of the spectrum because it followed the special consultative procedure with public submissions and hearings and was informed by numerous technical reports. These matters are relevant to the hearings panel's assessment of the weight that should be given to the spatial plan. Hopefully that's helpful. So the weight's with you, but hopefully that gives you some guidance and some assistance in determining how to place weight on it.
I mean, as commissioners, you get familiar with some of these cases, some of them get involved in. And I'm just wondering, is the Mallory decision also relevant to this as well? Because that involved a structure plan.
Yeah, I haven't got the facts of that at the forefront of my mind. I have looked at it on occasion, and I would have.
I won't go sending you down a rabbit hole if you had it sort of to hand.
Yeah. Perhaps I know we would have looked at it in preparing these and decided it wasn't the most relevant and helpful.
I think the examples are quite specific and quite helpful anyway.
Yeah, that review would have picked up Mallory because it's been around for quite a while. But what I'll do is take a look at it and address and reply if I think it's got any bearing or anything more helpful for you.
Yeah. And just before we move on, just again, that's something I've been wrestling with. And can you give us some legal advice as to what have regard to means in terms of a directive duty? What does have regard to sit with regards to some of the more directive things? I mean, it's used in the RMA in part 2. We know that.
Yeah.
And we've had lots of submissions right through the hearing that have regard to isn't much of a duty. And others would say have regard to is still quite a strong duty. Can you give us some legal advice on what that means?
Yeah, I mean, it's less directive than give effect to. So if you've got a situation where a higher order planning instrument like NPSUD is in conflict with the spatial plan or a document you have to have regard to, then the give effect to directive is going to override because it's a stronger requirement than have regard to. But I'm not aware that would occur here, for the reasons that I pointed out earlier, which is that it says the direction is that we've got to provide sufficient development capacity. It doesn't say where and how, which is what the spatial plan addresses. So I don't necessarily think there's a direct conflict there, but it is a lesser requirement to give effect to, but it's still an important one. And as that case said, it's genuine thought and attention. So you really do have to consider it and give it genuine thought and attention.
That's the words I said.
Yeah. So it's not necessarily.
So was that a specific case?
Yeah, it was. Paragraph 10.4, the first sentence, have regard to means give genuine thought and attention to the matter. And then in the footnote, there's a Court of Appeal case, which is often relied on that proposition, although it has been brought down into quite a number of RMA decisions as well. But it is the Court of Appeal, so it's a very high authority in binding on it.
Your section on weighting is particularly helpful to us, so that's really good. The case law that you quote has been dated. You have a comment on the dated nature of it. I've got 2011 by 2012, apart from the one that the chair was involved in 2007.
Yeah.
Nothing more recent.
Our review looked for what was available on the topic. So it didn't pick up anything more recent, and it could be a second. Yeah, it could be a factor of things becoming a bit more settled, but that was the best available on our review.
I mean, I suppose the other question is, should we interpret have regard to in the same way that we interpreted in Section 7 of the RMAs?
In Section 7?
Yeah, because it says have regard to the following matters. Is it the same test?
Yes, I see no reason
the
why. The
legislative test is the same as a non-statutory document test?
Yes, that's right, because the requirement to have regard to is statutory under Section 7 and under Section 74.
That's helpful, thanks.
Paragraph 10.13. As explained by Mr. Rubin, a spatial plan is a council-adopted document that sets out the strategic direction for urban growth within the Far North District over a 30-year period. The spatial plan was adopted by the council in June. The spatial plan process considered and evaluated a range of growth scenarios, which have been referred to as A through F. Quite a lot of the evidence refers to these scenarios, so you might need to familiarise yourself with them to understand the evidence. But that's just a product of having been through this spatial planning process recently and in parallel. Hopefully that's reasonably straightforward to get your head around. A hybrid scenario combining scenarios D and E was selected as a preferred growth strategy. This directs growth to within and immediately adjacent north of Waipapa and south of Kerikeri. The existing built-up environments of Kerikeri and Waipapa and away from rural areas. It provides for 20 to 40% of residential growth through intensification by enabling medium density development within established centres in Kerikeri and Waipapa. The KFO proposal was considered scenario F. The council decided to adopt the spatial plan based on a hybrid growth scenario, but acknowledged submissions in support of scenario F by resolving that scenario F should be added to the spatial plan as a contingent future growth area subject to conditions. And I've set out there exactly what the spatial plan states in that regard, because it is quite important to have that at the forefront of mind, exactly what the council resolved and what it decided. It's therefore not preferred or adopted by the spatial plan. It is, however, open to further consideration if the conditions can be met, i.e. progress through appropriate statutory processes, flood mitigation designed and funded by the developer, necessary infrastructure provided at no cost to the council, engagement and alignment with mana whenua, alignment with regional planning and community aspirations, and achieving support from the neighbouring golf club. Mr. Rubin and Mr. Wyeth consider that the relevant conditions have not been met. We also note that the contingent future growth area anticipates a future planning process. Implementation of the spatial plan through the PDP. The spatial plan can only be implemented through the PDP to the extent that amendments are within the scope of submissions. It follows that amendments that are outside the scope of submissions must be implemented through a future planning process. As set out in the Section 42A report, the intensification aspects of preferred growth scenario can be implemented through the PDPR. However, urban expansion to the north of Waipapa and the south of Kerikeri, which has not been sought in submissions, would need a future planning process. And in Section 11, funding and provision of infrastructure. This is obviously a key and critical consideration to this whole issue. In the context of any proposal which enables development, either immediately or on a deferred basis, the funding and provision of infrastructure should be central to the Section 32 evaluation, which requires consideration of whether a proposal is the most appropriate way to achieve the objectives of the PDP. The most appropriate planning method is driven by a matrix of factors which include infrastructure servicing. Other statutory considerations which are relevant to infrastructure include the requirement to give effect to the NPSUD as a whole, the requirement to give effect to the RPS in Part 2 of RMA. Importantly, integration of land-use planning and infrastructure planning and funding decisions is relevant to a number of the statutory considerations, including Part 2 of the RMA, to the extent it's relevant, the functions of a territorial authority under Section 31, the matters to be evaluated under Section 32, and the requirement to give effect to the NPSUD and the RPS under Section 75. In particular, Objective 6 of the NPSUD expressly requires local authority decisions on urban development to be integrated with infrastructure planning and funding decisions. And again, this is in paragraph 11.4, a relevant case which is often cited. It is, again, an older case, but not necessarily one that has been displaced or become less relevant over the years. In Four-Wheel Development Limited, the Environment Court considered certainty of infrastructure funding in the context of a deferred zoning proposal. The court stated without evidence, it is bad resource management practice and contrary to the purpose of the RMA to promote sustainable management of natural and physical resources to zone land for an activity where the infrastructure necessary to allow the activity to occur without adverse effects on the environment does not exist, and there is no commitment to provide it. 11.5, the underlying concern of the Environment Report was that unmeetable expectations are raised and the council is put under pressure to spend money it has decided as a matter of managing the city in an integrated fashion to commit elsewhere. That is the antithesis of the function of integrated management of resources imposed on territorial authorities by the RMA. So again, that's saying that by going through rezoning without sorting out infrastructure in advance and rezoning land and then leaving the infrastructure to be sorted out later, it creates an expectation and pressure on the council, which may end up costing it.
So are you simply saying that's bad practice for a council to do that? I mean, are we constrained by the lack of infrastructure? If we see a unit area of land, we think all the circumstances are appropriate for rezoning based on a submission, but there's no provision for infrastructure, no plan for infrastructure by the council. Are we constrained to declining that?
Not necessarily. It's open to you to consider that infrastructure in the context of all the relevant statutory considerations and how fatal you think it is. It's not a legal ban on rezoning, but it's bad practice and it's something that needs to be considered in the context of all the relevant statutory considerations.
So I mean that would likely, following on what you're saying, that would likely be lying idle without any development occurring because there's no infrastructure. So if it was to be rezoned, it could sit there for 10 or 20 years. Bad practice, I guess.
Okay. That's right. Either it sits there and nothing happens, or there's pressure brought to bear on the council to spend money in a way that isn't necessarily efficient in the interests of the district.
It's certainly not cool to be outside of Auckland and quote Auckland examples. And I know with the unitary plan, for example, with Judge Kirkpatrick, there were areas clearly zoned for future development. Like some developers, a number of developers seem to have picked up on that and said, well, we will provide the infrastructure ourselves. So I guess that's always an option itself, but there's limitations physically, practically in doing so.
That's right, and all those cases need to be considered on their own facts in terms of what the existing infrastructure is and what the planned infrastructure is and how far away it is, what the component of public infrastructure versus private infrastructure is. All these, they're all fact specific and every development needs to be considered on its own units.
So somebody like KFO, for example, they could potentially come along and say, we'll provide the infrastructure ourselves.
Potentially, but the question is really how much public infrastructure needs to go with it as well. For a smaller and more discrete development with public infrastructure already in place and planned, and the developer is more focused on internal infrastructure, for example, it's quite a different proposition to large-scale public infrastructure.
Fair comment. Thanks.
On matter 11.3, that interrelates with my prior question about the Three Waters entity and that important integration between land use planning and infrastructure planning. Now we have this other entity involved, which essentially is not the council, it's three councils.
Yeah.
And on top of that, we have a financial regulation body that actually puts a cap on how much we can spend and for plan for delivery within the 10-year period.
Yeah.
Yeah. I'm still unsure, and maybe you can provide clarity on that, about how this will interrelate with council's obligation currently with what the panel is deciding today.
Well, I think the NPSUD is silent about who the infrastructure provider is and what their planning is. For example, this covers NZTA, for example, which is not the council, and the same would apply to the new Northland CCO. So they can become the entity responsible for infrastructure planning, which needs to be integrated with land use development. And they'll sit there alongside the council, NZTA, electricity providers, other non-council infrastructure providers.
I think those timelines as well about the creation of the CCO, the movement of our three waters into that, the assets into that, and then also at the same time, on the other hand, with our wood planning, there's a lot of moving parts in that aspect, as well as the central government direction for statute as well.
Yeah, that's right. It's their comment.
Because we don't have that direction as a panel, there'll be additional questions that I have for the infrastructure area of council in a later time, and we'll be hearing from them specifically later in the day.
That's right. Probably your questions are for Mr. Hensley in the first instance. If there are things he can't assist with, we'll find someone else who can, or reduce the reply in our reply, in the council's reply.
Just to clarify, I mean, the term infrastructure, we're talking about the full range of public infrastructure, not just free water. When you refer to infrastructure, so that includes other things such as roading and social infrastructure. Sometimes, infrastructure can be this or can be that, and depending on what submission you're delivering.
It includes roading. Yeah, it definitely includes roading in terms of social infrastructure.
Parks and recreation, I think,
primarily. For the MPSUD definition, development infrastructure is free waters infrastructure and transport infrastructure. And then you've got a category of additional infrastructure, which is your social infrastructure.
So we're talking primarily about development infrastructure?
Yes, we are.
So that includes road?
Yeah.
No, that's helpful.
But it may help to refer to the definition of the MPSUD.
Yes.
But I take your point. We're more focused on.
Yeah, I think RMA is slightly broader than that.
Yeah.
Which one trumps the other one? Does it?
It doesn't really. It's going to depend on the context in which you're applying it. So if it's in interpreting and applying the MPSUD, then use the definition from that. So RMA provision, then use the definition from the RMA.
Thanks.
Paragraph 11.6, the court considered that providing for deferred development in the absence of a funding commitment from the council had the distinct potential to preempt analysis that is still to be done. These matters are addressed in the evidence of Mr. McDonald and Mr. Hensley. The decision on whether to accept or reject a rezoning proposal in the absence of planned and funded infrastructure is ultimately fact specific, which we touched on before. We need to look at the facts of this case. The other cases can really only take us so far. It needs to be determined in accordance with the statutory considerations summarised above. Mr. Wyatt's view is that the absence of planned and funded infrastructure is one of the reasons why it is not appropriate to include the KFO rezoning proposal in the EDP. At 12, my conclusion, the decision on a rezoning request is ultimately a matter of planning judgment for the hearings panel. The decision should be made in accordance with the statutory considerations and principles set out above. The planning limits are addressed by Ms. Trinder and Mr. Wyatt in the Section 32A report with the support of the relevant experts. So again, in these submissions, I'm not going as far as to tell you how to exercise your planning judgment. I'm assisting with the legal issues and the legal parameters, and I'll refer you to Ms. Trinder. So I'll go to any further questions now.
Well, thank you very much for answering our questions as we proceeded through it. So it was really helpful just to give us feedback as we went. So thank you very much for your legal submission. we're going to move now to the planners' presentations. Ms. Trina, are you going to go first?
Yeah, thank you, Ms. Fisher. I'll start off this way. Okay.
I think we'll go through your presentation and we might just take a little break and then we'll go to live.
I'm Sarah Trinda, the Senior Policy Planner at Parliament District Council, and also the report writer for all of the urban recommendations aside from KFO. So I just wanted to cover off some procedural matters. So Audrey Campbell Freer submission points were covered by both hearing 15C and 15D. This submitter has presented at this hearing, and also some of the submitters have been presented at hearing 15D last week, so just wanted to cover off the clarity. Also, subsequent to the release of my Section 42A report, I tabled a letter addressing the Department of Corrections further submission point to include community corrections activities as a permitted activity in the town centre zone. I recommend accepting that further submission point. Just a little bit about the process that we went through with our reports. The submitters were invited to opt into the Minute 14 first time process. We've heard a little bit about that already. Submissions were also evaluated against the Minute 14 criteria. This is detailed for those opted Appendix 1 to the report. Additional planning analysis included assessment around location, land use, site suitability, and growth demand, each of which is set out in my Section 42A report. Mr. Fisher has already touched on this a little bit, so I'm happy to answer any questions. With the adoption of the Kerikeri-Waipapa Spatial Plan, FNDC has acknowledged they are a Tier 3 urban authority. Hence, the Council needs to give effect to the relevant objectives and policies that would apply. Mr. Lindenberg has provided evidence for the Council which assesses these provisions of the MPSUD in relation to the PDP recommendations version and key considerations for the Council in terms of demonstrating how the intensification policies are relevant to Tier 3 local authorities and have been given effect to for the Council's recommendations to hearing topic 15D. It was considered that there are three broad options available to provide development capacity for Kerikeri-Waipapa. Option 1, the proposed district plan recommendations version, the PDPR approach. Option 2, Kiwi Fresh Forest Company Limited rezoning. Option 3, the PDPR package and KFO rezoning. A full Section 32 assessment of these options is included in Appendix 5. The PDPR package is aligned with the strategic direction of the PDP and the intensification principles of the spatial plan, and includes the following zoning recommendations for Kerikeri-Waipapa. Medium density residential zone over some of the existing residential zone of land. A town centre zone over existing mixed use zone of land. Upzoning of 23 Arunga Road from rural residential to general residential. A change in zone for 7.7 hectares of land at 126 Kerikeri Road and associated land holdings from general residential to mixed use. And as Mr. Fisher mentioned, introduction of a minor use unit as a permitted activity and other minor provision changes recommended through hearing 14 and 42A. We had 9 opt-in submitters, 6 of which provided further planning evidence and various other experts. Further rebuttal evidence was then received from Audrey Campbell Frere relating to the request for rural residential land and mixed-use zone for nodes around the Packhouse Market and Redlands. Turnstone Trust provided support for the Section 42A recommendations for the rezoning of 747 hectares of land from general residential to mixed use. LD Family Investments provided planning evidence in relation to the rezoning of land from heavy industrial zone to light industrial zone at Waipapa. Foodstuffs and McDonald's provided planning evidence in relation to the town centre zone provisions. And Northland Regional Council has provided planning evidence and technical evidence in relation to zoning of land at Waipapa. The urban rezoning request that I supported, as I've touched on previously, included Kainga Ora's medium density residential zone, which I have accepted in part. This recommendation builds on the recommendation from Hearing 14 urban zones and include provisions in spatial extent. Kainga Ora and various other submitters sought a town centre zone for Kerikeri. I have accepted these in part and built on my recommendation from Hearing 14, where I introduced the town centre zone. I am now providing the associated provisions and spatial extent. As detailed in both my Section 42A for Hearing 14 and this report 15D, the provisions and spatial extent have been informed by Council's experts and aligned with the PDP's strategic direction and the core outcomes sought by the spatial plan. It is compact around Kerikeri-Waipapa. I also recommended the rezoning of 7.7 hectares of Turnstone Trust land at 126 Kerikeri Road from general residential to mixed use, and the zoning of the Smart Life Trust site at 23 Aronga Road from rural residential to general residential zone. I also recommended a zone change for the Cherry House site on Landing Road to a sport and active recreation zone. That's all I've got here. I'm happy to answer any questions.
Yeah, that's good.
I think we'll just continue. Is this your section now, Mr.?
Yeah.
Sorry, I think we have some questions.
Sorry, I just have 4 specific questions, and maybe we'll start on this one here because it's on the screen, and it's the Smart Life Trust land, which you're recommending to rezone. To the north of that, there's a little sliver. What's the story with that? Is that going to stay how it is, or are you going to recommend rezoning that as well?
I think we didn't have any submissions on that portion at this time, so I think we need to consider it a little bit larger, but at this stage I don't have this.
So it's going to leave a bit of an anomaly there, isn't it, in terms of... Okay.
The reasons for rezoning of 23 along that outweighed.
Right, okay. Maybe we'll need to hear a bit more detail about that as we go, but we'll see how we go. Thanks.
Oh, sorry, I'll jump in there. So if we had the scope, have you considered what you would recommend if we did have scope?
If we had the scope, I would recommend rezoning.
Mr. Fisher, is there anything in our discretion that allows us to rezone land if it creates an anomaly?
No, the question is whether it's fairly and reasonably raised in the submission in a way that's going to put other people on notice that the zoning of that land could change so that they could get involved in the process.
Yes.
And if there's not, then you get a potential natural justice issue arising as the concern. With the Environment Court, they've got special powers under Section 293 to make out of scope changes if they follow the proper process, but unfortunately those don't apply to the hearings panel. So,
and if that party didn't make a submission, they wouldn't have had redress in the Environment Court either, right?
No, that's right. So unfortunately, it looks like
So that's where it is.
We're tied by scope. It's unfortunate that the submitter didn't extend their submission.
And so, as Ms. Brenda says, we just need to weigh the benefits of zoning the land and having an anomaly versus not zoning it at all.
Thank you. My second question, paragraph 119 of your report sort of leaves a question for us to deal with, and I just wondered if there was anything further that you wanted to say about that.
Sorry, is that in relation to very important evidence from the Kerikeri?
Okay, yeah, you seek the panel's direction around this, and if necessary, further work and recommendations can be made through the written right of reply. Okay, so we need to hear from the submitters, and then at the end of the hearing today or this week.
Correct, and this is in relation to Ms. Rennie's urban design.
Yeah.
I'll also note you have the opportunity to address any questions of Ms. Rennie.
Okay. All right. Well, then that then leads into Ms. Rennie's advice, where you also talk about at paragraph 105, the medium density residential zone. What I'm trying to grapple with, and probably putting Ms. Rennie on notice, is, you know, is there anywhere, any documents that actually describe the existing character of Kerikeri? You know, what are we dealing with? Has it been written down? And, you know, if there's people saying it's going to maintain this character, others it's going to destroy the character. You know, what is the character?
We have done some work around this in the spatial planning, but I think perhaps Ms. Rennie would like to address this a little bit further.
Yeah, okay. So maybe it's in the spatial plan from your point of view. Okay, thank you. And then my last question is just paragraph 175. I think there's a typo there. The last word of 175, introducing a town centre zone for Waipapa. Should that be Kerikeri? There's no town centre zone.
Yes, that is correct.
Okay, cool. Just to double check.
Town centre zone, just for Kerikeri.
That's
Okay, thank you very much, Mr. White. We'll have your summary, and then I think we'll take a break, because then we're going to hear from individual council officers after Mr. White. Is that correct, Mr. Willery? Yeah, so we'll have a break then.
Good morning, Chair and Commissioners. My name's Jerome White. I'm the reporting officer for the Kiwi Fresh Orange which has been touched on already today. In summary, there are 4 original submission points from KFO that relate to the rezoning of the site. And the proposal, as shown on the screen there, is broadly to rezone approximately 197 hectares of land between Waipapa and Kerikeri from rural production zoning to a mix of general residential, mixed-use zoning and natural open space zoning. The submission included a range of materials, including proposed precinct chapter, structure plan and a range of technical assessments. And as you'll be aware, they chose to opt into the rezoning process set out in minute 14, which allowed for evidence exchange. So the overall conclusion in my way is I do not support the KFO proposal, and that's for a range of reasons. Through this overview, I'm going to set out sort of 7 broader interrelated issues which provide the basis for that recommendation, and that has been informed by the experts that are here today. So the first issue relates to sufficiency of development capacity and risks of overzoning, uncertainties in the evidence, and debate as to what information there is needed now at the rezoning stage versus what can be addressed through future consenting processes. Flood risk and proposed mitigation, some of the anticipated adverse effects from the proposal, infrastructure servicing, uncertainty and risks, some shortcomings that I've identified with the precinct chapter, precinct plan, and alignment with higher order documents and the spatial plan. So in terms of the first issue, you'll hear from the economic experts on this in more detail, but the key point from my perspective is that updated assessment of development capacity has demonstrated it's sufficient in accordance with the MPSUD, and that includes the competitive margins which are not required for local authorities under the MPSUD. The implication for this is that additional greenfield growth is not needed at this point in time to provide sufficient development capacity, and especially not in the short to medium term, which is the life of the PDP. Also, to reiterate the point that enabling plan enabled capacity through the KFO proposal will not provide sufficient development capacity, as the KFO proposal was not infrastructure ready. It's unclear when that would happen, if and when that would happen. And also another key issue relates to the risk of overzoning, so that would be rezoning the KFO proposal in addition to what's been recommended by Ms. Trinder, is that it would undermine dilute some of the sort of concentration benefits that are sought for those recommendations in the spatial plan. In terms of outstanding matters, there are quite significant difference between the economic experts, and you'll hear from them today and tomorrow. And at a broad level, there's agreement that additional greenfield growth is required, and that's reflected in the spatial planning. The key issue for us today is when that's needed, i.e. does it need to happen now through the PDP or through a future plan change process, and where is the best location for additional greenfield growth. So the next issue is around sufficiency of information. This is kind of an overarching theme in the evidence of council versus KFO. And in my view, there's an over-reliance in the KFO evidence that sort of key critical issues can be addressed for future consenting processes, where in my view, there are some critical issues and information gaps that need to be addressed at the rezoning stage. And some of the key issues that you'll hear from today relate to ecology, flooding risk mitigation, infrastructure funding and delivery, transport and urban design. And from a planning perspective, the uncertainty and insufficiency in some of these mean the risks of acting and not acting need to be carefully assessed under section 32 of the RMA. And in my view, the risks of acting, i.e. zoning proposal now through the PDP, are potentially significant, which conversely, the risk of not acting, not rezoning it, are comparatively low, especially as we've demonstrated that there will be sufficient capacity in accordance with the FSUD. In terms of outstanding matters, the position of KFO appears to be that the information provided today is sufficient, that all relevant effects have been addressed. And at a broad level, there tends to be agreement around the matters that need to be addressed. It's just a matter of when they are addressed, which you'll hear more from the experts. Next issue relates to flooding risk mitigation. And in my view, there's sort of two kind of key issues here. First is a more fundamental issue around locating greenfield development in a site that's subject to such extensive flooding risks. And in my view, it's generally inappropriate to do so when there are feasible alternatives that avoid those hazard-prone areas. And this is reinforced by some of the technical evidence from Northern Regional Council, who you hear from this afternoon, that greenfield developments in floodplain areas using engineered solutions is inappropriate and out of step with current best practice, and particularly in light of flooding events that have happened throughout New Zealand and in particular Northland. The second issue relates to the level of detail on proposed flood mitigation. There tends to be agreement on the matters that need to be addressed between Mr. Jones and KFO's expert. But Mr. Ricks has identified some critical gaps that he considers need to be addressed at the rezoning stage. And the key issue here is that there's little certainty in outcomes in terms of what might be delivered, and this could result in some material changes to the proposed flood mitigations and the information that you're relying on to make your decision. Next issue relates to some of the adverse effects anticipated from the KFO proposal. Again, I won't go into details, you'll hear from the respective experts on this. But in summary, from an urban design perspective, there are some key adverse effects anticipated that relates to the loss of local character and identity of Waipapa and Kerikeri, poor connectivity and integration between the KFO site and Kerikeri-Waipapa, and an inefficient urban growth outcome compared to what's anticipated in the spatial plan. Traffic, again, limited connectivity is a key issue here, and a number of adverse traffic effects are anticipated, including increasing inefficiencies within the existing transport network. And Mr. Collins will talk in this in more detail, but there are a number of uncertainties, traffic modelling and assumptions, and that's potentially have quite a significant impact on the actual predicted traffic movements. Adverse effects anticipated, with a key one being the effects of the proposed floodway on stream and habitats. And lastly, more productively, the loss of approximately 100 hectares of highly related land that could otherwise be avoided through different urban design, urban growth outcomes. Evidence of KFO seems to certain provisions will secure a good outcome, and that relying on access point A and B, so they stay whole 10 and Road Drive, are sufficient. And there's also a revised proposal to rely on those two access points for up to 1,600 dwellings, which in my opinion is quite a significant change from a transport perspective. And ultimately, the lack of secured access into Kerikeri is quite a key issue that is expected to result in some key connectivity issues from a transport and urban design perspective that are quite difficult to resolve in the deployment process. Next issue relates to infrastructure certainty and uncertainty. We've already discussed this to some extent, but the key point here is that there are no specific details or commitments from KFO to demonstrate how the necessary development infrastructure, so that's your freeboarders and transport infrastructure, will be staged, funded and delivered. And the evidence of council is that this could create significant financial risk for council moving forward. As Mr Fisher said, once you've zoned the land, there's an expectation of development service. So you need to have sufficient certainty, in my view, about how that will happen prior to rezoning. And there's also, the evidence has also highlighted that the KFO proposal is going to be more costly in terms of infrastructure delivery compared to what's envisaged through the spatial plan, and funding responsibilities around transport and infrastructure have not been adequately addressed at this stage. Response to KFO, sort of responded saying upgrades will be prioritized regardless of where they go, but it might be about what's the most efficient way to do that. That they will provide funding for infrastructure. General assumption that infrastructure certainty issues can be addressed through the subdivision stage. Next issue relates to the chapter and plan. In my section 42A report, I identified a number of shortcomings in the precinct plan provisions, including that they do not address key issues, the relationship with other key provisions, including the natural hazards chapter, is unclear, uncertain terms and policy directions, and the precinct plan itself lacking detail. And overall, for urban development proposal of the scale, in my view, the precinct chapter and provisions lack the necessary certainty and precision that you'd expect to see from the development of the scale. KFO responded to some of the issues, but they also appear to overlook some of the issues that I've identified in my talk. And in my view, there's no reliance on the comprehensive development plan rule to address key issues and deliver quality outcomes. Lastly, I'll just briefly touch on higher documents, which has been discussed today to some extent. At a broad level, I agree that the KFO proposal aligns with some provisions in the MPSUD, particularly around competitive land markets, but in my view, there's inconsistent number of other key provisions in the MPSUD which need to be looked at and around, including those relating to well-functioning urban environments and enabling intensification in appropriate locations. As Mr Fisher discussed, there is a very directive test in the MPSUD, the MPSU HPL, around when urban zoning will be allowed on HPL. Three tests that all must be met. And in my view, those tests, the first two tests haven't been met because the rezoning of land is not needed to provide sufficient development capacity, and there are other reasonably practical or feasible options to provide that sufficient development capacity. In terms of this FM, the main issue here is around uncertainty of the effects of the proposed floodway on a potential natural inland wetland at the end of that floodway, and in particular because the proposed floodway is unlikely to meet the definition of specified infrastructure in FM, in my view, which could create significant consenting challenges down the track. There's some alignment with some RPS provisions related to economic well-being, for example. But in my view, there's also inconsistencies with key provisions relating to urban form and natural hazards. Again, with the PDP strategic direction, there is some alignment, but there's also poor alignment with key provisions, including urban form. So, as we said, it's not just a spatial plan that's trying to deliver conflict of urban form, it's also a key strategic objective in the PDP. Mix of housing typologies, resilience, and protecting hydrographic lands. And lastly, in terms of the spatial plan, Mr Rubin will cover this in more detail, but as has been discussed, it's contrary to a number of strategic objectives and principles in the spatial plan. In my view, the conditions for this as a contingent future growth area have not been secured, and there's a risk that decision that are inconsistent with the spatial plan will undermine the ability of council to deliver coordinated infrastructure support growth in the right locations. That's my presentation.
Thank you, very succinct. I covered a lot of things. Obviously, we can get into the detail of your particular issues as we go through the council witnesses. I think we'll probably save a lot of those questions for them and then perhaps come back to you at the end of evidence. I just want to confirm that in your summary, you have had regard to KFO's rebuttal evidence in providing that?
Yes. Yes.
In your reporting, you mentioned that the precinct plan provisions policies mentioned a structure plan, and you were unclear whether they included a structure plan. Are you clearer now that they've presented these?
It's another example of inconsistency. They still refer to the structure plan, whereas my understanding of the intent is it's the precinct plan that's now in the evidence.
So they're different terminology, but it's similar outcomes?
So I'm unclear if
You're still unclear
exactly what they're referring to. I'm assuming they're referring to the precinct plan.
Yeah.
Rather than it's an inconsistencies in provisions.
Okay. I will find that out from them.
Yeah, but that's my assumption is that that plan attached to planning evidence is what they're referring to, rather the structure plan and the original submission.
Okay, thank you.
I just realised that there was a question I wanted to ask Mr. Fisher that you've sort of reminded me of. So do you mind if I just veer back to him? My question for you is, where does a spatial plan as an instrument fit within the NPSUD, if at all? Because obviously the NPSUD talks about FDS, and it would seem to me that there are some FDS components in the spatial plan, but it's deliberately packaged in spatial plan. Are there any legal submissions to us?
The thing I touched on is that in clause 3.41 C, if you don't have a future development strategy, in this case because we're not required to, you can use a similar document to establish capacity. So in this case, Mr. Nickelrath relies on the spatial plan for long-term capacity.
Yeah. So again, because the Tier 3 authority, local authority is encouraged to follow NPS UD methodologies or approaches, the spatial plan sits within that general discretion. It's strongly encouraged.
Yes, I would think so. And Mr. Rubin can confirm this, but I understand that it has been the spatial plan has been influenced by the requirements for future development strategies under the NPSUD.
Yeah. Yeah. No, thank you for that. It's just a wee bit of a gap I wanted to sort of understand where the spatial plan sort of fits in terms of that. I understand quite clearly about having regard to other non-statutory documents. It's just about how a spatial plan fitted in with the direction or the encouragement of the NPSUD. So,
yeah. Thank you. That's an important question.
Yeah. Okay, look, I think this is a really good time. Are we okay to have morning tea now?
Yes.
Okay, so I think what we'll do is we'll do it in 3 minutes.
Yeah.
And all those people who are watching online, we're about to have a 20-minute morning tea break. So we'll see you all back about 5 past 3.
Okay.
Very good today.
I'm going to stop putting the recording.